Hi, everyone. Welcome to Up and Up Legal, Songs to Simplify the Law. My name is Christine Mathias. I am an attorney licensed in California, and today's video is about trademark infringement. So if your company has a trademark, either because you registered it at the federal level, the state level, or simply by putting your name out there on your products or your services, you have some rights if someone infringes on this mark. And by that, I mean they use the mark to sell their own goods or services. So one thing to keep in mind with trademarks is that the law is really there to protect the consumer. So when someone goes to a store and they purchase something, they see that name on there, they know that what that label is, that's actually the company that's putting that product out there, right? So, of course, trademark law also protects businesses in that you don't want other people making money using your name. But the thing to keep in mind is that the focus is really on the consumer. And so to that end, the government isn't going to be on the lookout for other people infringing on your mark. That responsibility is actually on you as the trademark owner. So oftentimes, trademark infringement is going to be really obvious. Someone is using your exact name to sell your exact same service or product, but sometimes it's not always clear. And so when that's not clear, really the question comes down to, is the consumer going to be confused? And so there's a few factors that the courts will look at to determine if the consumer would in fact be confused. So the first being obviously how similar are the marks or logos being used. But then we're also going to look at things like how similar is the product or the service. As in some cases you can actually use the same name, but if it's a completely different product, then that might be okay. It's also a question of the geographic area. If you don't have that federal trademark, you might not be able to stop someone on the other side of the country from using the mark. And another big consideration is the intent. So did the person use that mark? Did they know that you had that registered? Did you send them a cease and desist letter? Did you have that federal registration? That's not going to necessarily bar a claim, but it is something that will be considered and also might increase your damages. So those are just a few of the factors to look at, but to explore these ideas a little bit more, I got a song for you. If your company has a trademark and your customers know that logo name, but if someone else goes and uses it, well, you might have a case of infringement, but there's a few factors to look at. See if people really are confused, but if you're right, then you'll find that your rights are violated, you can sue, but some buyers are more sophisticated. They spend more time and money at the store to know what's mine and what's yours. Let's look at the strength of the mark. Was it distinctive or generic, and compare the two of the marks? Are they similar or different? And what about the services? Are the goods you're selling roughly the same? Is there any chance your customers are being confused about where they came? But sometimes the intent is relevant. Did they know you registered this mark? Do you want them to back away? And did they confuse anyway? Oh, you better protect your mark. So for more information, especially on that topic, you can head on over to mathiaslegal.com.